My name is Lindsay Sprague. I'm the Director of Member Relations. And today we are here to talk about 17A Guardianship. So I'm joined by Johanna O'Brien, who is a Special Projects Coordinator for the New York State Surrogates Court. And I'm also joined by my coworker, Nicole Hediger. She's a Member Relations Coordinator. So at some point during the presentation, I will put my email and Nicole's email and our agency website information in the chat so that you guys have it. I'm not going to do it now because I'm not great at multitasking, but I will at some point, so it's available. It's also in our PowerPoint, so you'll have that to reference as well. So our presentation tonight is going to provide an overview of 17A guardianship, what it is, whether or not guardianship might be right for you and your family, and an overview of the application process. Our webinar today is being recorded and will be available to view in the coming weeks. We also ask that you keep in mind that some of the things you hear in today's webinar might spark some additional questions for you in other areas of future planning, like about trusts or healthcare proxies or other advanced directives. But we are going to be sticking to the topic and questions of 17A guardianship, just to make sure we have enough time to get through everything. We're always here if you have questions about other areas of future planning. You can connect with us, you can connect with your care manager, and we'll talk about some other great resources that we have here at ACA. If you haven't already, please visit our website. It's full of great information. And on our website, you'll find our Knowledge Center, which has information on a variety of different topics, including future planning. So you'll find a lot more information there. We also have a community resource tool, and that is a tool to help you find resources in your community or providers in your community. And I will, like I said, put our website in the chat box at some point tonight. So our presentation should last approximately 15 to 20 minutes. Everybody here is asked to keep yourselves on mute until the end of the presentation, just so everybody can hear. There are quite a few of us tonight. The chat box is open, so feel free to ask any questions and we'll address them at the end. We'll also share the PowerPoint with everyone who's in attendance tonight, as well as the recording will be available too. I promise I'm almost done. We have language transcription services available. So if you need those, you'll see them at the bottom of your screen, like a little closed caption icon. You'll click on that icon and there will be a drop-down menu to choose from. You can choose your preferred language and the transcript of the presentation will appear on your screen. After the webinar, if you have additional questions, like I said, you can email me, you can email Nicole, and we'll always do our best to follow up with you and get you the answers that you need. I do want to give a little overview of our team. So we are the member relations team. We work alongside care management. So we're a support in addition to your care manager. And I say that because it's really important for you all to know that if you have questions, if you have concerns about anything, really, you should feel comfortable asking your care manager. So we are not in place of care management. We work alongside care management to support our membership. So with all of that being said, I'm going to get started on our presentation. I'm going to present the slides, and Johanna, our Special Projects Coordinator from New York State Surrogates Court, might jump in. She might answer some of the questions at the end. She's the real expert on this topic, so I may defer to her. But Nicole's going to move our slide along for me and we'll get started. Thanks for listening to my long introduction. Um, so today we're here talking about guardianship, and I'm sure you're all here because you want to plan ahead. So if as long as everybody here, just so everybody here knows that when your loved one or your child turns 18, you as the parent do not automatically become their guardian, right? Even if they're unable to make important choices and decisions for themselves, that is a legal process that needs to go through your county surrogate court. So in New York State, when people turn 18, even if they're diagnosed with an intellectual or developmental disability, they are assumed, just like you or I, to be legally competent enough to make their own decisions. So if your loved one, your son, daughter, the person that you're here in attendance for, is unable to make choices for themselves, safe choices, maybe they struggle to make those more complex choices, you can communicate and connect with your county surrogate court to appoint a guardian. So not everyone with a disability needs needs to have a guardian. For this reason, before you're pursuing this type of guardianship, 17A, it's really important that you learn about other ways and other less restrictive opportunities you have to support your loved one. So some of those things might be power of attorney, healthcare proxy, supported decision making, which is a huge one. And we can talk a little bit more about that at the end if folks are interested and have questions. There's also Article 81 guardianship. So it's really important to make sure that the folks that we serve with disabilities have the right to make choices as they're able, right? And it's a really important mission for us to help members and families understand that even if they need help making some choices, they don't necessarily need to have a guardian. 17A guardianship, once appointed, does really change the level of decision making that the person with the disability is able to have. So who can be a guardian? Any person that's 18 years of age or older who is of sound mind and has not committed a serious crime can be appointed a guardian by the surrogate court. In preparation for guardianship proceedings and exploring guardianship, it's good to know that you'll have to obtain a certification from one physician and one psychologist or two physicians. And basically these documents will attest that the person who has a disability isn't able to make choices for themselves and needs the support of a guardian. So for most courts, the date of examination by these medical professionals must be within a certain time frame, right? So if your child is 19, it's not going to be sufficient to present a document from when they were 15. But you'll want to check with your county surrogate court to be exact on those time frames. That's a good question to make sure that you ask. Other documents might be required based on each person's situation. So you'll want to make sure you visit newyorkcourts.gov, or again, call your local surrogate court for more information.
Right, Lindsay, let me just add that these
Yeah.
certifications, they're forms that the physicians or the psychologists fill out. And what most courts like are the supporting testing that your child or your loved one has gone through. The testing can be a little older because we know sometimes it's usually a triennial every 3 years. There's some sort of testing. But the swearing to the by the physician or the psychologist need to be within the year.
Perfect. Thank you for clarifying, Johanna.
No problem.
All right. So, Nicole, we can go to the next slide. So a big question that might come up for you is, do you need a lawyer to file 17A guardianship forms? And the answer is no. The guardian application can be time consuming, but it's not difficult. And there are free kind of do it yourself, start your own petition programs and that you can find on the New York State Court's website. So we can post those in the chat as well later on. And again, you can always call your your county surrogate court clerk. I heard from the last presentation that we did on this, I wasn't there, but word on the street is that person will be your best friend and knows all of the answers to your questions and will be an excellent resource for you. And there may be small differences depending on where you live. So it's really good to connect with those folks and kind of get the rundown right from them. So there are fees associated with the process. There's a filing fee. There's a guardian ad litem fee. Possibly we'll talk a little bit about that later on in the presentation. But again, you're encouraged to speak with your specific county's court to talk with them about your financial situation. If you self-direct your services, you can talk to your support broker about using the self-direction budget to support the costs of guardianship. Your care manager can also support you through this process by calling the courts with you, gathering information for you that your care manager might know or could find out information about local resources in your community that might help with the guardianship process. So, for example, I know many of the ARC agencies around New York State have programs that specifically help folks through guardianship and really do a good chunk of that work alongside you. So, next slide. Thanks, Nicole. What information is required on the application? So you'll need to know the name, address, and phone number of the person that you would like to be the guardian for. You'll have to indicate your county, who you are to the person. And if you are a parent, you will have to indicate if there's another parent who could also be considered as for a guardian. Your educational level, and then information about the person that you're applying for guardianship for. So there are also folks called standby guardians. So the standby or alternate standby guardian is appointed by the court to serve upon the death, incapacity, or renunciation of the primary guardian. So this is a backup, right? So if something were to happen to you as the guardian, you can establish ahead of time who will take over those duties.
And they do have to petition after they get to move in immediately to be the guardian, but then they do have to petition to confirm their guardianship within 120 days.
Great. Okay.
Yep.
All right. So there will always be a hearing. So when you're petitioning the court for guardianship, there will always be a hearing that follows your petition. And you'll receive a hearing date from the court after your initial guardianship application is processed. So during the hearing, evidence is presented to the judge showing why the petitioner feels that the person needs a guardian. And then as a result of the guardianship hearing, the judge may officially appoint a guardian by issuing a decree in letters of guardianship that will give specifics about the situation of guardianship. So whether it's guardianship of the person or guardianship of the property or both. Johanna, could you talk a little bit about like what guardianship of a person is and what guardianship of property is?
Right. So when it's a 17A, we most courts primarily go with the guardianship of the person. And that makes the guardian have the authority for all the medical decisions or financial decisions, basically any decision that needs to be made on behalf of the person, the guardian will take care of. If there is property, the guardian would also take care of property, which is basically bank accounts, or if there's real estate that the that is inherited for the person. What it doesn't cover, it's we have no jurisdiction over any Social Security disability or anything like that. It's basically monies that the ward has either earned or um, inherited, and every um, account that will be joint now with the clerk of the court and the guardian, and these accounts have to be and every at the anniversary of being appointed the guardian of the person and property, you'll have to do an annual accounting and tell the court what the funds are, and we make sure that nothing was dispersed unless it was under court order. So it does get to be a little more involved. And most of the people that we have guardianship 17As really don't have these funds. Or these funds are in maybe a supplemental needs trust or in an ABLE account or in something else that have been created before the guardianship went through, and then the court doesn't have, we call it, jurisdiction over these funds. So there's many different ways to explore how to preserve these funds, but yet still have the person get their entitled benefits. So those are good things to explore with, I don't know, Lindsay, if your agency would do that, or an attorney to help set up SNTs and things like that.
Yeah, so that's a great point. Supplemental needs trust, or ABLE accounts are definitely something you want to work with an attorney on, but there are, like everything, attorneys that kind of specialize in those areas, right? And have an expertise in those areas. So that's definitely something to ask your care manager about, if you're looking for those resources. And just a quick plug, we are having another family forum next month on ABLE accounts. So we'll have some folks from the comptroller's office here to talk about ABLE accounts. So you'll see those, the flyers for those, and a link to register for those forums coming up in your emails, just
And
like you
they
said.
and that agency does require a guardian of the property, which does not make sense. And we've been trying to work with them, and we will put in the guardianship letters that the guardian is allowed to open an ABLE account, so that we don't get guardianship of the property for that person. It's just guardianship of the person, but with that extra authority to open an ABLE account. And they seem to have accepted those types of letters. It's a little confusing when you get between the different agencies, you know.
Yeah, yeah. Okay, so let's move along to the next slide. So, does an individual with the disability have to attend the hearing? If there is a hearing, then the person with the disability is usually required to attend, but it sounds like most courts will allow virtual appearances and are able to use Microsoft Teams. So next we're going to talk a little bit about guardian ad litem. So a guardian ad litem is an attorney that the judge appoints to represent the person with a disability when guardianship is being pursued. So this person will contact you to schedule an appointment and meet with you and your loved one that you are requesting guardianship for. The guardian ad litem is an officer of the court, and they'll prepare a report that will be used in the guardianship hearing. Are there costs associated with a guardian ad litem? they are entitled to compensation for their work, but they may also be awarded continuing legal education credits or pro bono credits. So again, please connect with your local surrogate courts and discuss your financial situation with them. Don't let this be a barrier to asking questions or finding out more about the process. And then lastly, we just wanted to mention that when someone lives at home in the community with their families or independently, this is the process that we've talked about. But if somebody lives in a residential setting, like an IRA, an individualized residence alternative or a group home, there is involvement from mental hygiene legal services. So MHLS is appointed by the court instead of that guardian ad litem, but they act in the same capacity. We wanted to make sure we mentioned that in case some of you have loved ones who are living in a certified setting.
And then there is no fee. Mental
With
hygiene doesn't
MHLS, good point.
charge. Yeah.
So I'm actually, Nicole, can we put up the next slide just so folks have a chance to write down our emails? So I'm Lindsay, I'm the director. Nicole is one of the coordinators that works on our team. And then our supervisor, Pam, wasn't able to be here tonight, but she's also a great resource. So here are our emails if you want to write them down. And then I'm just going to take a quick second to let folks type their questions in the chat. And while we're doing that, I'm also going to put our ACA website in the chat like I promised. So just go ahead and type your questions in. All right, so I put it in the chat, but it may get lost. So for those of you who can't see it, our website is acany.org, and that's where you'll find our knowledge center with tons of good information about future planning in general, and lots of other good stuff too. So I'm going to go ahead and read through some of the questions. Oh, it looks like there were some issues maybe with the translation services.
Lindsay, may I just say that the do-it-yourself program on the court website is also in Spanish. So you can choose either English or Spanish. And when it prints out, it will print out in English. So even though you're filling it in Spanish, it comes out English for the court.
Beautiful. And we also have some great connections, especially out in the New York City area, for folks who, we have one woman in particular who knows a lot about this guardianship process. She works for New York Public Lawyers, I think it's called, and she is bilingual. So we may be able to reach out to some of the folks who struggled with the translation services and connect you to her. Name is Paula, and she would be a great help. So the first question I see is, what if the other parent has a criminal record? So I'm thinking this is probably in context to when we said you'd have to indicate if there was another person that could be considered guardian. Johanna, do you have any info on that?
Actually, Lindsay, the statute changed. You can be a felon and be a fiduciary. So that isn't a hurdle anymore.
Okay.
If there is, we do background checks through the Office of Court of OCSF, background checks. And if there are what we call indicated reports of child abuse, then we will probably send out probation department to do a home study. But if don't let it stop you from petitioning to be a guardian if you do have some sort of criminal history. It'll just be disclosed and discussed with the surrogate, but it's no longer a hurdle. Okay.
Sorry, I had a hard time unmuting myself. Okay, thanks, Johanna.
Mm-hmm.
Um, can both parents be guardians, or does only one get appointed as guardian?
You may have co-guardians. You can have as many guardians as you'd like, but it's easier if there's only two guardians or one. But yes, you may have multiple guardians, multiple standbys, multiple alternate standbys.
Great. So Alyssa says she would love to have information on agencies that help. So Alyssa, we'd be happy to reach out, either Nicole or myself, and connect with you and send you some resources, and also connect with your care manager as well. Can a grandparent apply for guardianship of a child she has raised solely without the parent?
Anyone can petition, especially if you have court appointed custody. We will ask for orders, copies of any orders in the family court or whatever the situation is. But yes, the grandparent can apply.
All right, so here's a good question. What if a client, so I'm assuming this means the person with a disability, disagrees with someone becoming their guardian or does not feel that they require a guardian?
And that's why we have a guardian ad litem. We have an attorney appointed for them to protect their rights. So it would then go at the hearing. Um, Evidence would be, um, given, and there probably be further conferences, and it would be an extended, um, you know, uh, multiple court dates and things like that. So it would go down that path. But that's why supportive decision making is such a wonderful thing that's being developed and has been developed, but now is part of the law. So there's other avenues to explore.
All right, so if the petition isn't done within those 100 days, what does that mean for the member and the secondary person? Okay, so if it's now time for the standby guardian to step in and a petition hasn't been filed in the appropriate time frame.
The thing is that the court's not going to come out looking for you. It's if you try to use the authority with an agency or with the hospital or someplace that says you're not appointed, that's where the trouble will be. We're not going to not accept a petition because it was not filed timely. It's just you're opening yourself up to not being able to be the guardian. So it's best to get on it within the those 4 months, and at least reach out to the court and let them know the guardian is no longer able and that you're working on the paperwork so they can note the file.
Great. Oh, Susan would like to learn about ABLE accounts. We have one coming up for you next month, Susan, so I'm sure we'll see you there. What if guardianship was set up before the person earned his own money? There is no required reporting under the old 17A guardianship. Does that change when the standby takes over?
We're finding a lot that when the original guardianship was done, the statute has changed, the laws have changed, and we're not reviewing. Well, and every court is different. We're looking at the standby petition, we're looking at the old file, and we're seeing what maybe the holes are between the two, and trying to um, not trying to stay within the law. So it's that this is a really good gray question, we call them. So it depends, and we'll have to look at it. Your court will look at it and decide. Um, it can be that now that they have funds that need to be taken care of, you can be changed to be guardian of the person and property, or the other way around. Um, it's a good time to like look at it, refresh the guardianship, see if everything is still needs to be in place.
All right. If the advocate is undocumented, can they still file for guardianship?
Yes, we don't stop, depending, on their status, on the guardian status.
Can two parents be named co-guardians? I think you already answered that. Yes.
Yes.
Oh, this is a good one. Can you explain the difference between 17A and Article 81 guardianship?
Well, I really don't have a good handle on the Article 81. I've only for the last 23 years been working in the surrogate court. So the 81, from what I understand, can be tailored to specific needs, and may have a different diagnosis for the individual. It might be more of a psychiatric situation as opposed to an organic situation. So best to speak with an attorney who knows the difference, or the agencies. I'm sure, Lindsay, you know more than I.
So, I mean, my understanding of Article 81 is that it kind of like you're saying, more for folks who struggle with mental health issues or kind of like become incapacitated or can go from being of sound mind to not being of sound mind, where it kind of shifts. Whereas 17A is more for the folks that we serve who don't have much change in their capacity from day to day. I don't like to use the word capacity, but I think it is as direct as I can be. So I agree with Johanna, though. Definitely reach out to your local court. Ask your care manager for help in researching that or connecting with folks who could really describe the ins and the outs of that. If the child is hospitalized and unable to speak for themselves, can the parent advocate on their behalf if no guardianship is in place?
If they're under 18, yes, no problem. If they're over 18, it's up to the hospital.
Yeah, I was gonna say in my years in carrying a caseload and supporting folks in care management, that really has been my experience, that it's kind of up to the hospital, sometimes even up to the specific doctors. I'd like to say that most medical facilities would, of course, like welcome you as part of the team, but I think it will really be specific. Then you can, there are also other options, right? Like healthcare proxies and stuff like that that you could explore. Um, what is the current turnaround time being between filing in the court and a hearing?
I say in the normal world, which we haven't experienced in the last few years, it's about a 6, 8 month from filing to getting your decree. And it's a process. So you file the petition, and then there's other forms that you complete, background checks, fingerprinting. So those are outside agencies. So we have to wait for them to report back to us. And then we look and see what the reports say to see if we need then probation or corrections or whatever. So until all the paperwork is correct and into the court, we can't then schedule the hearing date. And most hearing dates, if everything was done today, March 28th, 28th? Yep. The hearing would probably be May. So it's like another 2 months out because of the scheduling of the court calendars. Um, so then after the hearing depends on what happens at the hearing. If the person comes in and says, I don't want a guardian, then that goes further down the road. If everything's in agreement, everything is good, then it goes for decree and decision, and within 90 days that will happen. So it's a process. 6, 8 months. That's why you really should start well before the child is going to be 18. If you start like, right around 17, and then that way it'll all be in place before they're 18. But you can always do it afterwards. We understand life happens.
Sure. Okay. How would I now add a standby guardian? At the time, I had no one for both of my sons, but now I would like to add one.
That's very easy. It's actually the same because we don't have a different petition. Um, it's the same 17A guardianship petition, but you're just going to add in information about the standbys and you'll add in their consents. And then at the end of the petition, there's what's called a wherefore clause. And it's all the things you want to happen. So it's actually a fill in the blank. So you're going to, continue your as guardian, and now you're adding in the standbys.
Perfect. So my son is 17 and will be turning 18 this September. Is it too late to start the process? Definitely not. Um,
It's never too late. We have guardianships for, adults that have been in their home and the parents have passed away at age 80, and now we have adults at 50, 60 that we're getting guardianship for. Their siblings are coming in, and that is fine. You know, every family's different. So
yeah. Okay. How about the parents if we are not residents or citizens? We already spoke to that. That
yeah,
doesn't matter.
yeah.
Should an able account, disabled trust account, or a supplemental needs account be set up before the 17A guardianship?
I can only speak about the supplemental needs trust. And again, explore all with, a legal attorney. But it depends on what the funds come from. We do have a lot of petitions where they're petitioning for the guardianship and approval of the SNT at the same time. So it can be done at the same time or afterwards. But it also depends on the funds that are funding it. So there's many different types of supplemental needs trusts, which you can explore with an attorney.
All right. Is there someone I can talk to in detail about my situation and which guardianship, if any, I should seek? Absolutely. You can start with your care manager. Your care manager can help you explore different kinds of guardianship, whether it be 17A or 81. Your care manager can also help you explore less restrictive options like supported decision making or healthcare proxy. Like you said, really dependent on the details of your situation and your loved one and what you're looking for at this point in your lives. So definitely start with your care manager. And then I would be looking probably to find attorneys in your area that specialize in that area, or those agencies that we talked about, right? Like the provider agencies like ARC that have guardianship programs. Definitely lots of different resources. It'll just be about connecting with your care manager about the resources in your region. You can also reach out to Nicole and I, and we're happy to connect with you about the details of your situation. And again, help support your care manager to ask different questions or to locate different resources. If we have power of attorney and a healthcare proxy for our son, would a guardianship be preferable under any circumstance?
I don't know. Lindsay, I'm leaving that one to you.
So, I mean, I think it depends on your family situation and the details of your situation, details of your son, and just what your family dynamic is. Um, I think it sounds like healthcare proxy, that's great, obviously, for medical decisions, but it really just kind of depends on what you're looking to gain or what the goal is of these processes for you. So please feel free to reach out to us and we can talk about your situation in detail, connect with your care manager, and talk those specifics through. Who can help us fill out the application? So the application is very easy. Like we said, it is time consuming, but it's very self-explanatory. But if you're looking for support with that, definitely contact your care manager. Um, Johanna, is there anyone like at the surrogate court that helps with that kind of thing?
Well, if you look at the do it yourself, it walks you through and it asks the questions, and they have little pop-ups if you need clarification of what they're asking for. And then you just type it in, and then the little avatar walks down the path. It's very user friendly, and there's been a huge success with doing it. And there's also a checklist that you can print out with all the paperwork, um, again, from the court website, and it will ask all the questions, and we've had success with that. And like Lindsay says, it's not a difficult application. It's very repetitive. Like who's your information, who's, you're the person you want the guardianship for, you know, with the grandparents' information, who are the standbys, it's just, and who are the doctors filling out the forms. It really isn't a difficult application. And the court will then review it, and they'll review it with you and go, oh, you missed this line, write this in, fill this part out. And they will go through it. And also the supporting documentation, the ones from the physicians are usually the ones that are most difficult to get from the physicians, and those are the ones that are scrutinized very much by the judge, because they're going on what the doctors are saying instead of bringing them into the hearing and having them testify. So this is their testimony for the case. And those may take some time to get completed, because we know the doctors are very busy and they just want to sign something and, give it back to you and not fill out every line, which is needed. But the application really is not a difficult um, thing to fill out. But yes, like Lindsay said, you can reach out, and I'm sure that you have people that can assist too.
Um, yes, definitely reach out to your care manager um, if you need help with that process. Um, and the next question is, when do we get the physician's forms? I'm assuming, Dominic, you mean, can we have a little more information on that? So I think you said, Johanna, that's the form that the physician signs off on. That's the one that has to be done within a year of the petition.
Right. They have to review all the supporting documentation for the different tests, IQ, whatever, all the other tests that they do. And they have to see the person within a year. The supporting tests don't have to be within a year, because we know they're done every 3 years or so. Um, but the physician has to sign his paperwork within the year. So
So
say
here's
you
a
get all of that in, like, December, you can file it in May, when you're getting all your papers together.
So here's a good question I feel confident about answering, at least one of them. Would a life plan count as testing or evaluation? And I'm gonna say probably not. Johanna, correct me if I'm wrong, but I would imagine the testing that's submitted to the court needs to be done by a psychologist or a psychiatrist, a clinician. It has to be probably formal IQ testing, maybe some adaptive testing, and care managers don't do those. So those are going to be things that you probably get from a school psychologist
Yes.
or an outside clinician, maybe that your child or loved one sees. It probably doesn't have to come from school, but probably many of them do, I would imagine.
Yes, that's the easiest one to get, is the school psychologist with the IQ and
Sure.
the other Welcher. I apologize. I don't know all the testing names, but
Okay.
yeah.
Um, A life plan, so Johanna, our life plan is basically a plan of care for the members that we serve. So it might be a great supporting document to submit, but probably not going to do the trick in and of itself. I had a client whose guardian had died during the initial COVID-19 lockdown. Oh, geez. That must have been so hard.
We've had quite a few.
Yeah.
Yep.
What is the difference between power of attorney and 17A guardianship?
Again, I'm not an attorney, so the guardianship would be to put a guardian in place. Power of attorney means that this person has the ability to give authority on specific things to another person. Again, another thing to just, discuss with an attorney.
Sure, that makes sense. That's their area of expertise.
Right. Just like the
Oh,
question.
Susan's wondering, what is supported decision making? Is that different from guardianship? So I want to talk a little bit about that. We will have other forums and information coming up on supported decision making, but I'll try to summarize it. Supported decision making was recently signed into law in New York State. And what supported decision making is the person with a disability doesn't lose that level of independence that you lose when you have a guardian appointed. So instead of people making decisions for you, it's like people making decisions with you. And it's a very formalized process now, and it continues to become more formalized and as it gets bigger. But basically, there are advocates that work in the circle with the member and facilitate healthy decision making, right? So just like you or I might talk to a family member if we have a tough choice to make, it's really formalizing that process for the person with a disability. So at the end of the day, they're still driving the car, and we're just kind of passengers holding the map for them, right? Or holding the map with them. So supported decision making is really cool, and I'm really excited about that for our folks, and we'll definitely have more information coming on that. Right. What about out of state? Like, for example, from New York to Florida. So I'm wondering if this means, like if the guardian were to move from New York to Florida, or does the guardianship decree travel from state to state?
So there is a process of transferring a guardianship from one state to another if needed. You may keep your guardianship in your original state. It follows where the person is residing. So if they move with mom down to Florida and you want the guardianship transferred there, then you go to the Florida court. The Florida court says, okay, we'll take it. They send New York court an order saying, we want this. And then New York will say, okay, you may have it, and would send them an order. It's like a back and forth kind of process. But yes, you can transfer your guardianship from New York to your new state, or you can transfer your guardianship from another state to New York. It works the same way if needed. Sometimes they'll say, no, you need guardianship in our state. And then you'll want the transfer. Others will say, oh, you had it in New York. Oh, it's fine in Georgia. Yeah, but you have to check with the state and the agency that you're seeking to work with.
And you would suggest doing that by reaching out probably to the surrogate court in that county. Yeah. Okay.
Yes, in both states. If you move to Florida and Florida says no, we want the guardianship transferred, then you go to the court in Florida and start the process, and they reach out to New York, and New York and Florida start talking, and then eventually the file will be transferred down.
All right. How many standby guardians can you have?
You can have as many as you'd like. You can have standbys, you can have first standby, second standby, alternates. the petition has room for a lot of different people, because we know sometimes when it gets to that point that maybe one is more involved than another, maybe one's closer, and so it makes more sense that, standby number one is not viable anymore. Let's go to standby number two. So you can have whatever you can think up is fine.
Okay, where would folks get the form for the doctor to fill out?
It's part of the paperwork on the nycourts.gov website. And you click on forms, then surrogates court, then guardianship. So that brings you to different pages.
And just a reminder, another plug to reach out to your care manager about this. This is certainly something they could come sit with you and look at together. It's not in this alone. You don't have to do it alone. Um, so we do only have 5 minutes left, and there are several questions that are very specific. So I would really encourage you, again, if you have really specific questions to your family, reach out to your care manager, reach out to Nicole and I or Pam, and we're happy to help you kind of work through those specifics. Um, just scrolling through, I think I'm nearing the end. If you already have a guardianship of property decree, then apply for 17A. Will that speed up the process?
Nope, it's two different processes.
Okay. What if a person's guardian passes away and they are now interested and able to self-advocate?
And we have had that. Again, that's with maybe they had a older, and we know the brain keeps developing in people until, late 20s. So maybe they put the guardian in place at 17, and now you have someone who's 20, 25, 30, who's a totally different person than they were at 17. And we have had guardianships that we just vacated, and now the person can go on and maybe do supportive decision making. So, and we have also had guardianships done, and we've done them temporary until the person becomes 25, because we see the development from when they were 14 to 17 was a big jump, and maybe they're not quite there at 17, 18, but let's see again at 25 what that looks like, and maybe then we can do the supportive decision making. So the courts are really trying to not put guardianships, and I'm talking about Westchester again because that's where I was for 17 years. And the other courts are coming along as well. They really don't want to put in a plenary guardianship if there's progress and there may be another person in 10 years than the one they're seeing right now. Does that make sense?
Yeah,
Yeah.
it's
So
also really exciting. Yeah.
I the first time it happened, I was like, yes. Yeah, it
Um,
really is.
as far as the attestations from the doctors or the psychologist, Johanna, do folks need to wait until the person turns 18 to have those signed off on?
No, 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 not at all. Not at all. Get them in because you'll need them in with the petition. So again, it's best to do it, you know, 17, 17 and a half, start the process.
All right. When the time comes, can guardians make end of life decisions for the person?
The statute says it has to be involved with a physician. So they can't do it themselves. They have to have a physician involved. And that's the statute,
All right.
the law.
I think we might have time for one or two more. Do I need to fill out the whole 17A paperwork to just add a standby or just the part about standby guardianship?
Since you've already have a guardianship, you can say see file number, whatever your file number is in whatever court, um, and then add in maybe the information that's changed, like if you're changed addresses or things like that. Again, check with the court because maybe they've developed their own form to use instead of one of the state official forms that kind of get jerry-rigged, to make it work.
All right, so it's 7:59. We didn't get through all of the questions, but we got through a whole bunch of them. So again, I just wanted to say thanks to Johanna for being here, all your expertise. You knew so many answers to those questions. But we will be sending the PowerPoint out for everybody that's been in attendance. And please, please, please don't hesitate to reach out to Nicole or I with your specific questions. Or again, I really encourage you to connect with your care managers. They'll have a wealth of information that they have access to, and they'll help you out. So thanks again, everyone, for coming. And I'm going to stay on just for a little bit in case anybody has any pressing questions. And then we will hop off and maybe talk to some of you
I
another.
do see something about e-filing. Yes, you're more than welcome to e-file forms. Most of the courts want the original doctor affidavits and the original birth certificate, which most courts give back the original birth certificate after the decree is signed. Right.
Lots of thank yous, Johanna. Great information. So thanks again.
And
Thanks
really
everyone for
reach
coming.
out to your courts and your care manager because the courts, the guardianship clerks are more than willing to help as well. Thank you.
El último finalista, Pepe, Jameir, Pepe, Jameir.